3, 2, 1, start. Shri Gupta further argued that in the present case, what was prayed for was a writ of quo warranto, and in fact, the election of the appellant was not called in question. It was argued that since the writ petitioners came to know about the appellant not belonging to the scheduled caste, and since the post of the chairperson was reserved only for the scheduled caste, therefore the High Court was justified in entering into that question as to whether he really belongs to scheduled caste. In short, the learned counsel argued that independent of the election of the appellant as a ward member or as a chairperson, his caste itself was questioned in the writ petition only with the objective to see whether he could continue as the chairperson. This argument is clearly incorrect as the continuance of the appellant as the chairperson was not dependent upon something which was posterior to the appellant's election as chairperson. It is not as if some event had taken place after the election of the appellant which created a disqualification to continue as the chairperson. The continuance of the appellant as the chairperson depended directly on his election, which election was available only to the person belonging to the scheduled caste. It is an admitted position that ward number 8 was reserved for scheduled caste, and so also the post of chairperson. Therefore, though indirectly worded, what was in challenge in reality was the validity of the election of the appellant. According to the writ petitioners, the appellant could not have been, was not at the place of occurrence. She therefore might not be aware of the details as to how the accident took place, but the fact that the first information report had been lodged in relation to an accident could not have been ignored. Some discrepancies in the evidences of the claimant's witnesses might have occurred, but the core question before the tribunal and consequently before the High Court was as to whether the bus in question was involved in the accident or not. For the purpose of determining the said issue, the court was required to apply the principle underlying burden of proof in terms of the provisions of Section 106 of the Indian Evidence Act as to whether a dead body wrapped in a blanket had been found at the spot at such an early hour, which was required to be proved by the respondent numbers 2 and 3. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied.